Good morning, sir. Are you James Wheeler?
Yes, ma'am.
And let me get myself up to speed here. Mr. Wheeler is currently on probation in cause number 23 DCCR 1800 for the offense of fraudulent use or possession of identifying information. There was an administrative hearing filed, sent over back in May of 2024, and a motion to revoke that probation filed. Allegations of committing the new offense of public intoxication, testing positive for methamphetamines, testing positive for amphetamines, not adhering to a curfew, being behind in his fees a little bit, and then failing to report for intake in Hardin County. It looks like a recommendation of SafeP after a substance abuse assessment was done on April 16th of 2024 that returned to probation May 7th to discuss the recommendation. Denied using drugs, however, allegedly tested positive on that day. And before the matter could be addressed, left the building. Advised his officer that he was going to make arrangements to go to his own detox program in Austin. Probation said, can't pick what you want to do. And so we're here now with the motion to revoke. Mr. Kimler has filed a motion asking that I set a bond. Mr. Wheeler is on a deferred probation, typically entitled to a bond unless there's certain findings. Actually, this is a straight probation. It's a 2/5. Okay, I've received some information that Mr. Kimler sent over. Do you have an opportunity to review that? Mr. Kimler, you may proceed. Did you want to call your client?
Well, I think I'll let him decide that, Your Honor. Just speaking on his behalf, if he wants to address the court, I'll let him do that. But this is a non-violent offense. My first observation, of course, many times when I move before the court, I know that the state argues the safety of the community is paramount in consideration of bond. I'm not trying to downplay the seriousness of fraudulent use of identifying information offense, but I would just observe to start with that it's not a crime of violence. Mr. Wheeler's struggled on probation. We want to get him back on track, and as part of that, it would be admission to bond where he could report, continue to work, hopefully not have a positive drug screen so that he can come back in front of the court for a disposition of the case. The court's going to revoke him or keep him on probation and be in the best possible position to argue that he should be continued on probation.
Speak up, please.
So that he would be in the best possible position to ask the court to continue him on probation if he would have the opportunity to be in bond, so that he can demonstrate compliance.
Okay, Mr. Nichols.
If he's, whatever bond the court deems appropriate is fine by me, Judge. He just needs to monitor. He needs a drug patch. He needs to be reporting. And seems to have a problem doing those things when he was on probation before. I'll note for the court, on a separate probation, he was sent to safety in 2020.
I saw that.
And obviously it has not worked. So I agree it's not technically a violent offense, but his drug use is concerning, Your Honor.
Do you want to address the court?
If I may.
Hold on. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
I have had a history of drug use. When August 4th, my firstborn child was born, and when I heard her cry, I was done. I never touched it again. I put myself in the Franklin house as lay manner, and I went there for 30 days doing aftercare. CPS was with us up to taking 9 drug tests, negative, and a hair follicle. I'm just ready to provide for my family, and that's why I turned myself in, so I can go back and get this out the way and fixed to where I can go to work, because I couldn't get a job because of the warrant. And I I'm really excited to be a father. It's really, I'm trying to put this on the right track so I can get moving.
So one of the things I did get one of those letters is from the caseworker that had some positive things to say. So I'll deal with the bond. I'll set one, but what's the plan? I mean, do we not want to go ahead and go through the motion while we're here, and that way we can then set it for, instead of coming back? So will he waive the formal reading of the motion? So we're going to go through this motion, get pleas of true or not true to those allegations, reset it for sentencing, and then we'll talk about the bond and conditions of that in just a minute, okay? So I have in cause number 23, DCCR 1800, motion to revoke your community supervision, shows that you were placed on probation March 19th of 2024 for fraudulent use or possession of identifying information. That was a 2-year term in the state jail prison that was probated for 5 years. Is that right?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the offense of public intoxication March 26th of 2024. And is that true or not true?
Yes.
Count 2 alleges that you provided a urine sample April 16th of 2024 and May 7th of 2024 that tested positive for methamphetamines. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample April 16th and May 7th that tested positive for amphetamines. Is that true or not true? I'm sorry.
True.
Count 4 alleges that you were at a location other than your residence at approximately 11:15 p.m. March 26th of 2024, and is that true or not true?
Yes.
True.
True.
Count 5 alleges that you are, as of May 7th, 2024, you were $240 behind in your fees. Is that true or not true?
True.
And then count 6 alleges that you failed to report to the Hardin County Probation Department for your intake on April 9th of 2024. And is that true or not true?
It is true, but hard to
True with an explanation.
Yeah, we'll get an explanation later. All right, so did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And so I'll get a little more information about what's going on. Now, with regard to a bond in your case, I'm going to set a bond at $5,000, but you're going to have a condition of that bond if you make it, that you have to wear a drug patch at all times. You've got to have a drug patch put on within 24 hours of your release from custody. If it tests positive, then you're back in jail and all bets are off.
Thank you so much.
If there's more, if you have a drug patch that's not testable, I'm going to assume it's positive. So you need to make sure, wear it properly, do whatever you need to keep it on, and go every 2 weeks like you're supposed to get it tested. I think, I don't know exactly what I'll do. I mean, obviously it sounds like some treatment would be required. Wouldn't hurt to go ahead and get started on some outpatient maybe. But we can wait, or you can go ahead, probation's here, and whatever you think is appropriate at this point while we're waiting on sentencing, give those orders and I'll sign off on them.
Yes, ma'am. I was going to give him a new assessment down to see exactly what it is that he needs and get him started.
Perfect. Okay, because it sounds like since the last assessment, there's at least been some treatment, so maybe that'll, recommendation will change. Okay, all right, you can go back with the bailiff.
Here we have a lifelong criminal who has been charged with credit card and debit card fraud. He has violated every possible probational period that he has received for past crimes, but he received another softball sentence. Sit back and let's see how this case plays itself out. Make sure you subscribe and like this video.
Good morning. Are you Christopher Bishop? And will your client waive the formal reading of the motions and the new indictment?
Yes, Your Honor.
Mr. Bishop, in cause number 24 DCCR 1659, you're charged with the state jail felony offense of credit or debit card abuse from May 29th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $300 fine and pay restitution in the amount of $45.95. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bishop is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. So is there any reason, I see probation's here to get a pre-sentence report. It looks like the other cases are all to be continued. Is that correct?
Yes, ma'am.
Any reason to get a pre-sentence report?
No, ma'am.
And for probation, you're in agreement with all of this as well? Okay. So I'm going to, yes, ma'am.
I believe, are we abandoning count 1?
Hold on, I'm not there. Let me get done with this new case yet, and then, yeah. I'm going to, again, find that you entered that plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of credit or debit card abuse, sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. You're ordered to pay a $300 fine. You're ordered to pay that restitution in the amount of $45.95 and follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and, you could be, your probation revoked, and you could go to state prison for that 2 years that you've already agreed to. Do you understand?
Yes, ma'am.
Okay. In cause numbers 18-29813, 17-26803, 17-26802, and 17-26800. In all of those cases, I have first amended motions to revoke your unadjudicated probations. Shows that you were placed on probation in 3 of those cases for burglary of a habitation on December 4th of 2017. And those were 8-year deferred probations. Is that correct?
Yes, ma'am.
And then in the 18-29813 case, you were placed on probation November 26th of 2018 for burglary of a building, a state jail felony. Shows that was an 8-year deferred, so that must have been enhanced.
I believe it was a burglary of habitation.
Okay, let's make sure.
Because the paperwork on the tablet has habitation that we did.
PSI shows it was burglary of habitation.
Let me look back at the actual plea documents and stuff like that real quick. So that, he was on probation, committed that one. and
This
then
one
got-
was done a month before the others, but it wasn't indicted until afterwards.
Okay, thank you. So do you want to make an oral motion to amend that 18-29813?
Yes, it should be burglary of habitation.
Any objection to that? And then after, instead of state jail felony, second degree felony, correct?
Yes.
Any objection to that, Ms. Jones? Okay, so in that final case, you were also placed on 8-year deferred probation for the second degree felony offense of burglary of a habitation. Is that correct?
Yes, ma'am.
Okay. Now, each of these allege that you violated your probation.
That's abandoned count 1 in each case.
All right.
This is dismissed.
Thank you, sir. All right. The state's elected to abandon count 1 in each of those cases. Count 2 in each of the cases alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
It's true.
Count 3 in each case alleges that you tested positive February 8th, March 18th, June 6th, June 11th, July 1st, and July 11th for tetrahydrocannabinol. And is that true or not true?
It's true.
Count 4 in each case alleges that you failed to submit to a substance abuse assessment and follow the treatment plan. Is that true or not true?
It's true.
Count Count 5 in clause number, I hate it when they're not the same. Count 5 in clause numbers 17-26803 and 17-26802. In each of those cases, count 5 alleges that you're behind in your court assessed fees. And is that true or not true?
It's true.
And then count 6 in those 2 cases, count 5 in the other 2 cases alleges that you committed the new offense of credit or debit card abuse on May 9th of 2024. And is that true or not true?
It's true.
Did you enter your pleas of true to all of the counts except 1, which was abandoned, in all 4 of these cases? And did you plead true to those counts because they're actually true?
Yes, ma'am.
Give me just a second. Get organized here. In each of these cases, I have here on the computer documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you also go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And you understand also if I follow these agreements, you'll be waiving or giving up any right to appeal.
Yes, ma'am.
And it looks like the agreements is that you would remain on probation. I would continue your probation. I would extend it in each case for 2 years. I would order as a condition of your probation that you enter and successfully complete the substance abuse track of ISF, and that when you get out, you would go through the JCDI program as your aftercare. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Let me get caught up here. In each of your cases, I'm going to find that you entered your pleas of true freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probation, but I'm not going to do that. You're getting a great opportunity today. I'm going to continue you on each of those probations. In each case, I'm extending your probation for 2 years. I'm ordering as a condition of your probation in each case that you enter and successfully complete the substance abuse track of the ISF program, that you successfully complete the JCDI program and follow all of the rules and conditions of probation. I'm also going to order, well, I'll get to that in a second. In these 4 cases, you're still on that deferred probation, which means you don't have these felony convictions. Take advantage of this opportunity, get back out, get on the right track, and you'll never have these convictions. At the end, the cases will be dismissed if you're successful. But as a reminder, if you violate again, you'll be right back in here. It's very unlikely that you will get the same opportunity again. And in these cases, if you violate, you could get up to 20 years in prison. Do you understand? All right. Now, I want to go back real quick. In cause number 24 DCCR 1659, which is that new case, I'm also going to order as a condition of that probation that you enter and successfully complete the substance abuse track of ISF. I want it ordered in all of the cases. It just keeps it a little cleaner as well. And also the same JCDI program when you get out. Do you understand? In just a second, I'm going to hand you, did I print one yet? 803 is what I printed. 800. Okay. Nope. Here, it's coming. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, so you've waived your right to appeal. Give me just a second. It's taken it a very long time to go from here to there. Okay, and then I also need to go over, when I hand you all of those, I'm also going to hand you an admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment in that new case, that credit debit card abuse case, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read this written admonishment that I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right? Good luck to you, sir. Take advantage of this opportunity.